Can the passage of 65 years truly insulate a state official from the consequences of a political assassination, or is the legal concept of a statute of limitations finally collapsing under the weight of colonial history? In a landmark ruling that has sent shockwaves through European diplomatic circles, a Brussels court has determined that a 93-year-old former diplomat must stand trial for his alleged complicity in the 1961 murder of Patrice Lumumba. This case centers on Étienne Davignon, the final living individual among 10 Belgians accused by the Lumumba family of participating in war crimes during the chaotic dawn of Congolese independence. The stakes extend far beyond a single verdict. They involve the fundamental integrity of the European legal system and its willingness to adjudicate its own imperial past. This investigation will uncover the specific mechanisms of the alleged crime, the shifting stance of the Belgian judiciary, and the global precedent this trial sets for accountability in the post-colonial era. If this legal process successfully moves to trial, it marks a seismic shift in how international law handles state-sponsored political murders. A successful prosecution would signal that high-ranking officials cannot hide behind the concept of the moral responsibility of a state to avoid individual criminal liability. Conversely, if the case is dismissed on appeal or fails in court, it may reinforce the perception that colonial-era crimes are effectively beyond the reach of modern justice, creating a permanent shield for aging state actors. The situation fundamentally changes the dynamic between former metropoles and their previous colonies, moving the conversation from symbolic apologies and the return of artifacts to the cold, hard reality of criminal dockets and potential prison sentences for war crimes. To understand the gravity of these charges, one must look back to 1960, when the Democratic Republic of the Congo transitioned from a Belgian colony to an independent state. Patrice Lumumba, a charismatic nationalist, became the first prime minister at just 35 years old. His vision for a truly independent Congo, free from the shadow of Belgian economic control, immediately placed him in the crosshairs of Western interests and local secessionist movements. The Katanga region, rich in mineral wealth, declared its own independence with the backing of Belgian mercenaries and mining interests. By January 1961, Lumumba and two associates, Maurice Mapolo and Joseph Okito, were captured, tortured, and executed by a firing squad in Katanga. For decades, the details of their deaths were obscured by a shroud of diplomatic deniability, though a 2001 parliamentary inquiry eventually admitted that the Belgian government bore a moral responsibility for the events. The specific allegations against Étienne Davignon, who arrived in the Congo as a 28-year-old diplomatic intern just before independence, are precise and categorized into 3 counts of war crimes. The Court of First Instance in Brussels maintains that he was involved in the illegal transfer of Lumumba and his associates from Leopoldville to the hostile territory of Katanga. Furthermore, he faces charges regarding the humiliating and degrading treatment of the prisoners and the deprivation of their right to a fair trial. While Davignon's defense argues that the reasonable time for a trial has long since passed and denies any participation in war crimes, the family's legal team emphasizes that the gravity of such offenses means the passage of time cannot erase legal responsibility. The family views this not as the end of a long struggle, but as the actual beginning of a historical reckoning that the legal system has avoided for over half a century. The modern timeline of this case was accelerated by a 2022 ceremony where Belgium returned a gold-capped tooth to the Lumumba family, the only physical remain of the leader, kept as a souvenir by a Belgian officer involved in the killing. During that event, Belgian leadership acknowledged that while no evidence proved an explicit intent to assassinate Lumumba, Officials should have recognized that transferring him to Katanga placed his life in imminent danger. They suggested that the state chose to look away rather than act. However, the Brussels prosecutor's surprise referral in June 2025 and the subsequent court ruling have moved the needle from looking away to active criminal complicity. If no appeal succeeds, a full trial is projected to begin in January 2027, making Davignon the first Belgian official to face a criminal court for this specific political murder. Consider a scenario where this trial establishes a definitive link between mid-level diplomatic orders and the eventual execution of foreign leaders. This could trigger a wave of similar criminal filings across Europe, targeting the remaining elderly officials of the 1950s and 60s colonial administrations in North Africa and Southeast Asia. In another scenario, the trial could stall indefinitely due to the age of the defendant, leading to a massive diplomatic rift between the European Union and the African Union. In such a case, the failure to reach a verdict might be interpreted as a deliberate tactical delay, fueling modern anti-Western sentiment and complicating future resource and security treaties. The geopolitical consequences of this ruling are profound. It challenges the sovereign immunity usually granted to state actors and suggests that a domestic court in a former colonial power can and should judge its own citizens for crimes committed abroad during the era of decolonization. It forces a re-evaluation of the global order, moving away from a system where history is written only by the victors and toward one where legal accountability is persistent. The case of Étienne Davignon represents the tension between the desire for stability and the demand for justice. As the 2027 trial date approaches, the world will be watching to see if the Belgian legal system can truly confront its own history. The next few months of the appeals process will reveal whether the international community is ready for a new era of legal transparency, or if the shadows of 1961 will remain unpierced. The pursuit of justice in this instance serves as a litmus test for the modern global order. For the descendants of those who suffered under colonial rule, the trial represents a long-awaited acknowledgement that no official is above the law, regardless of the era in which their actions occurred. For the legal community, it is an exploration of the limits of jurisdiction and the permanence of international humanitarian law. As we move forward, the focus remains on whether historical truth can be reconciled with modern legal standards. Viewers should watch for the outcome of the impending appeal and how other former colonial states respond to this unprecedented judicial move.